I'm here to talk about how you choose your data protection officer and conduct a privacy impact assessment. And maybe some of you are even wondering, why do we need a data protection officer? Why do we even need to protect data? Well, primarily because we live in a data-driven economy, and data is the new oil of the digital economy. And just like oil in the 18th century created billions of dollars of wealth for those who knew how to monetize it, data will also create billions of dollars of wealth for those who are monetizing it today. Companies like Uber, the largest transportation company, as Commissioner Dondi O said, Airbnb, and Facebook. And yet, Uber does not own a single car. Yet they have data about where you are now and where you want to go. Airbnb does not own any hotel rooms, but they have data about where you want to stay and how long you want to stay. And Facebook does not have any printing presses or production studios, and yet they have data about who your friends are and what you like to read. And all that data allows them to create a lot of wealth. Data is also used by government to improve the delivery of public services. For example, in this recent story from the Manila Bulletin, Barangay Bunuan Bukig in Dagupan was able to reduce the incidence of dengue. And the hero that defeated dengue in this story wasn't medicine, it was big data. So clearly there's a need for us as government agencies to collect data, lots of data. But remember, as Commissioner Dondi O said, there's also a corresponding obligation to protect that data. Because we need to keep in mind that our data is under attack all the time from cyber criminals and identity thieves, whose actions cost $126 billion in 2015 and affected 689 million people. And they do this by going after personal data, data in banks, data in hospitals, and most especially data in government agencies, because this is where most of our personal data resides. And that is why the Data Privacy Act of 2012 requires all government agencies to have a data protection officer to avoid situations like this, the Comelec. 55 million Filipinos have been put at risk, and most especially the over 1 million voters who registered overseas and whose passport details were part of the data that was breached. Imagine what would happen if this passport data ended up in the wrong hands of terrorists or cyber criminals. These Comelec victims could suddenly find themselves on a no-fly list, and they wouldn't be allowed to board a plane. Or, as they apply for a visa to go to a job abroad, they're denied a visa application. So let me ask, how many of you have a data protection officer? One. Yes, sir. What agency? UP Manila. Congratulations. Who else? Wow. Well, no, PhilHealth. You have a data governance committee, right? Okay. So data protection officer can actually be one person. It can be a committee. And by the end of this session, hopefully, you'll be able to explain the following things. Why do you need to have this DPO, and why do you need to have a PIA? And people will probably ask you, okay, I understand the need, but how do we select a DPO? And so I'll also cover some considerations in selecting a DPO. And then you might be asked, well, we don't really need that, right? Maybe we can make do without having a DPO. And so I will cover some of the possible consequences of failing to designate a DPO. Sometimes you may not be sure also whether you have the right DPO. You might appoint an acting DPO because you also have to conduct your privacy impact assessment. That's step 2. And sometimes after the privacy impact assessment, you realize you need a more senior DPO. Or maybe you actually need a committee, like in the case of PhilHealth. So it's important to understand why you also need to conduct a privacy impact assessment. And if we have time towards the end, I'd like to share the Commission's thoughts on the difference between compliance versus accountability. All right, so let's go with need. This is in the Data Privacy Act and in the IRR. right? It says that a personal information controller, which is you, the agency, must designate an individual or individuals who are accountable for compliance with the Act. Doesn't say whether you call this person a chief privacy officer or a data protection officer or a privacy manager, right? So that's because this is an omnibus legislation. It impacts public sector as well as private sector. So in order to be specific for the public sector, we prepared Circular 16-01. And 16-01 is now very clear. It says that you have to designate someone who's called a data protection officer. And the one who has to do this is the head of agency. We also require that you must conduct a privacy impact assessment program for each program, or privacy impact assessment for each program, process, or measure within the agency that involves personal data. So you may actually have 5, 10, 15 assessments, right? It's not just one for your agency. You already have one that you need to do for HR, right? Because HR is a process wherein you take in applicants, you hire them, you pay them, and so on. So you have to do a privacy impact assessment for your HR process. But you probably also handle personal data of constituents, of citizens, right? Of loan applicants, and so on. So that's at least another assessment that you need to do, and there may be more. So basically, that's why you have to do it, no? Because it's an obligation, because you're required by Circular 1601. And so the question will now be, okay, so who should it be? Should it be a lawyer? Should it be an IT person? Actually, one size doesn't fit all, right? And there are many organizational options. You can have a full-time or a part-time. And in the case of the National Privacy Commission, that's myself, one person, I'm doing it part-time. In the case of the Department of ICT, Secretary Salalima appointed 2 DPOs, one to handle the external data, one to handle their internal data. UP Manila, sir, is this a full-time, part-time? You do other things, right? If it becomes clear that you're handling a lot of risk, as in the case of PhilHealth, that's what they did. They put together a data governance committee. And in some cases, like maybe the COMELEC, which suffered that COMELEC. And if you think about it, COMELEC is the only agency that has biometric data of 55 million Filipinos, right? That means that they should probably even have a data protection office. One size doesn't fit all, so it really depends on whether you're low risk, medium risk, or high risk. And on the next slide, I'll give you a very quick way to determine whether you're low, medium, or high. But keep in mind that at least the minimum requirement should be met, that whoever is designated DPO should know what it is they're getting into. And that means that they should at least have a basic knowledge of privacy principles and practices. The person should also be aware of what issues, strategic issues, what concerns, what priorities are facing the agency, right? So that he or she will know what kind of impact assessments need to be done. And that means, therefore, that the DPO should probably be a member of the executive committee or the management committee. As I said, I will show you a matrix. It's pretty much an eye chart. Tomorrow, we will go over this in more detail, and I will help you to ascribe points so you can be rated from 0 to 100. But I'll just flash it now so that if you don't have this information yet, tonight, you can gather that information for the workshop tomorrow, okay? But if you handle sensitive personal information, then you're high risk. And the definition is contained in Section 3 of the Act, in Section 3 of the IRR, and Commissioner Libor explained it earlier. The volume of records, if it's low volume, maybe you're small LGU, low risk, but if you have more than 1,000 records, medium risk, and up to the millions, right, or 1,000 or more, high risk. Origin, many of you handle records of Filipino citizens, but some of you, like for example, the DFA handles visa applications, because there are other countries that need to apply for a visa to come into the Philippines. And so DFA collects all of that data to assess whether they should be given a visa or not. Bureau of Immigration issues work permits of foreign nationals. So you have to be aware also of the types of regulations regarding data protection of the countries from which those nationals are coming from. Access, of course, if it's limited to on-site, then it's low risk. You know, you see who's accessing it. If you have on-site as well as off-site, maybe some regional, international offices, medium risk. If you have external parties, such as other agencies or the public themselves accessing that information, then that's high risk. Time of access, if you limit it to 8 hours, well, that's good. You only need one shift to guard it, and then, you know, at 5 o'clock, you pull the cable, basically no one can access. But if you're doing 8 to 12 hours, then you're talking multiple shifts, and if you're talking 24 hours, you're basically online all the time, then you're high risk, right? You follow the logic, right? The more people can access, you know, from more places, the higher the risk. Like if you have less than 50 users, only 50 people have the password, right? And you pretty much know if there's a leak, it's confined to those 50. If you have up to 250, then the risk is higher. And if you have 250 or 1,000 accessing that database, then clearly you're high risk. Response requirement, if you do not have to give an answer in sub-minute or sub-second time, then that gives you a lot of time to validate whether the access is a valid, correct type of access to your database. But if you have to respond, you know, to thousands of requests in sub-second response time, it becomes more difficult to validate each of those requests. Storage media, if you have paper, I know many of us still have paper or microfilm or microfiche. Well, it's pretty much low risk because you can look and see whether the paper is there and if anyone's accessing it, right? But if you're digital, medium risk. The highest risk is if you have both, right? Because you have to have both types of control procedures, one for the paper and one for the digital. Storage location, if it's one site, medium, multiple sites, higher risk. And do you have big data projects in your agency right now? If you don't have any plans, okay, no risk. But if you're planning to do something within 3 years, medium risk. If you're already doing something now, then you're high risk. So get into this sort of thinking. Now, this is called the risk-based approach, right? You don't just comply and say, oh, we've complied because that's what the law says. You also have to know, you know, to what degree of magnitude your response has to be. How qualified or how senior does your DPO have to be based on the risk? Right? You can't just say, well, I appointed someone, I've complied, my job is done. You know? Risk-based approach says, assess your risk and then decide on who your DPO should be, and what level, what kind of support should be given to the DPO. What does a DPO do? Okay, there's a handout, I believe, in your packs. So we can just go over this quite quickly and do a countdown. You know, of course, number 1, be the privacy champion within your agency. Number 9, because we're counting it down, right? Number 8, be involved in a timely manner in all issues which relate to privacy and data protection. That means that you are allowed to insert yourself in any project, in any meeting. The minute you hear that someone somewhere is going to be doing something with personal information, you should be there. And this approach is called privacy by design. You know, and Dr. Liliana will talk a bit more about that later on. Then you have to coordinate with those who are responsible for related disciplines and functions within the organization, right? You're not going to be a legal expert, but you have to coordinate with the legal department when you talk about things like service level agreements, contracts with service providers. You're not going to be a training expert, but you have to relate to HR, because HR will schedule all these classes, whether they be online or face-to-face. You have to coordinate with IT. You have to coordinate with security. And so you really become an orchestrator and a conductor, and that's one of the key roles. Number 6, as I said, you orchestrate all of those programs, right? Because once you know what each of them are doing, you then need to put them on a timeline. Take care of all of the precedents, right? Make sure that they're lined up properly. All of those critical path method, right, to see that you're achieving, the end, which is having a privacy program in place, a privacy managed program. And as Chairman Liboro said earlier, that needs continuous assessment and revision. Because as you start, you may have a simple framework, such as the one we've given you today, but then when you evolve, like I said, risk-based approach, you might realize that that is just too simple for you, and so you may want to look at several more advanced frameworks. Number 5, keep up to date on relevant privacy issues. Now, as a DPO, you need to be abreast of automatic processing, machine learning, differential privacy, de-identification, and how all of these tools and techniques will help you to achieve your compliance, right? And number 4, you have to maintain confidentiality, right? Because as the DPO, you will be exposed to certain investigations, complaints. You will have to go around and check for compliance. And while checking for compliance, you will be exposed to sensitive personal information, right? So you also need to maintain that level of confidentiality. Number 3, monitor compliance of the agency with the Act, the IRR, and the guidelines for circulars. And here there's a story around this, Other countries have data protection authorities just like us. And whenever an investigation is enacted upon them, they go to the agency and they say, can you show us your compliance? And some of those will say, can you give us a week? Okay, after a week, they come up with a report this high, and they submit it to the DPA. Sometimes after a week, they go back and say, well, you said give us a week. We gave you a week. And then they'll say, actually, we need 2 more weeks. Question mark, right? Because now the DPA is wondering, are these guys really compliant, or are they just coming up with documentation, which never existed in the first place? And so what's important when you talk about compliance is having software support. Every time, you actually may have a matrix that says, this is the document that proves that I'm compliant with this provision of the law. And the latest version is stored on this file location. And the person who's in charge of maintaining it is this person. This is their email address. This is how you contact them. So that's the type of compliance management that we would like to see. Sure, it will require some type of maturity. Maybe in the beginning, what you have is just an Excel spreadsheet that tracks all of that. And there are actually Excel spreadsheets that you can download for free from the web that will assist you in doing this. And as you mature, you may be able to move up to software as a service type of applications. Because, this is not new. Hundreds of countries around the world are already doing this type of compliance. And so tools are available. You may want to look into those types of tools. Number 2, respond promptly to complaints or inquiries from data subjects. Right? So data subjects will come to, as we said, this is the role of the DPO. And the DPO has to be able to reply to them, because if you don't reply to them, then they may file a complaint with the NPC. And then we become the one to step in to do an investigation. Which leads us to role number 1. Drum roll. The most important is to represent the agency in its dealings with the National Privacy Commission. And there are 3 types of dealings that we will have. First is an inquiry. Second is an inspection. And third is an investigation. What's the difference? Inquiry is something that we will initiate. So maybe we heard something, we saw a news article, and we decide to go to your agency and just an inquiry. We just want to check. Okay. Second is inspection. This is what you initiate. Right? You might want to say, we're implementing this framework and this ISO certification, but we want to know if we're on the right track. Right? And so you ask the NPC to come and do an inspection. The third type, investigation, is the one where it's a data subject who has a complaint, and we verify the complaint, and we've seen that there's something behind it. And so we'll actually start sending out summons, subpoenas, doing forensic examinations. In other words, it's a full-blown investigation. Let's go on to the third objective of this session, which is to inform you what are some of the consequences of not designating a data protection officer. Right? And so we go back here to the Data Privacy Act. Again, it says that the controller shall designate an individual. And in Section 22, it now says, at least for government agencies, the head of each government agency shall be responsible for complying. So the head of agency is actually responsible for compliance with, 1, appointing a data protection officer, 2, conducting a privacy assessment, and so on. Right? Because if the offense, shall be opposed upon the responsible officers who participated in, well, probably the head of agency will not participate, right? But who by their gross negligence allowed the commission of the crime. And if your head of agency does not appoint a DPO, that might be construed as negligence, might even be construed as gross negligence. And negligence is never predetermined but ascertained on a case-to-case basis. I think that one situation that many of us are familiar with is you go to hospital, you have an operation, the next day you go home, then you feel a pain in your abdomen, you get an x-ray and there's a pair of scissors that someone left. Okay, who's negligent? Right? Was it the nurse? Was it the surgeon? Was it the head nurse? Was it the head surgeon? Was it the head of the Department of Surgery? Was it the president of the hospital? Right, who failed to implement controls and procedures for doing an equipment count, making sure the proper training is in place, putting in place, the organizational structure to keep those controls active. Right? So it's a case-to-case basis. And therefore, what that means is if an offense is committed, as Commissioner Libora showed earlier, there are many types of offenses. It's possible that, because you haven't appointed a DPO, the head of agency might be found guilty of gross negligence, for data being improperly disposed or maliciously disclosed or processed in an unauthorized manner. And as mentioned earlier, the gross negligence is there. If it's committed by a public officer, an accessory penalty consisting in the disqualification to occupy public office for a term double the term of the criminal penalty. Right? So if the jail term meted out is 5 years, then there's a 10-year period where you cannot serve as a public officer. 5 years, of course, will be in jail, but another 5 years out of jail, disqualification from serving as a public officer. So this is definitely quite a heavy penalty, any way that you look at it. We talk now about the need to appoint a DPO, but the question is, which comes first, right? The DPO or the PIA? Because again, depending on the level of risk that comes out in the PIA, you may decide later on that a more senior person is needed or additional support staff is needed. And so what's the PIA all about? It looks something like this. It's a matrix which would list down all the processes, programs, and measures. So this agency has 4 processes. And for each of the processes, we look at the privacy risk. And privacy risk is quite simply the probability that the data processing or other activity may result in a loss of the rights and freedoms of an individual. So here we see that process X1, there's a high risk, process X2, a medium risk, X3 has a low risk, X4 has a medium risk. But privacy risk in itself doesn't tell you much, right? What you now have to do is assess it against the benefit that the constituents or citizens might get out of that process. And also against the controls that you need to put in place to manage that risk. And here in the case of process X1, which is high privacy risk and the benefit is low, the decision there is let's not even think about controls because already it's unacceptable. Second process, medium risk, medium benefits, but the complexity and the cost of controlling that risk is quite high. And so the assessment is unreasonable. For process X3, low privacy risk, but high benefit and low complexity of controls, it's almost a no-brainer, right? That's acceptable. And X4, medium, 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 acceptable. So what you do now with this assessment is that you then look at, these are the controls we need to implement, these are the types of projects, and therefore, what type of a DPO do I need? But it's not static, right? Because sometimes your assessment may change over time. Maybe the cost of implementing those controls is reduced because a new technology or a new innovation comes out that makes it cheaper and easier to implement. And so you might then say, okay, X2 becomes acceptable. And therefore, we need to appoint more support staff to our DPO, so on and so forth, right? So this has to be seen as a dynamic assessment. You have to do it quite often. In fact, when you do a privacy impact assessment, this lists down 6 different situations. If you're going to initiate a privacy management program, like you are now, start with the PIA. If you're going to implement a new process or a new technology, something that you haven't done before, do a PIA. If you're scaling up, let's say you have an existing process which was only in one office, and now you decide that we're going to have it in all regional offices across the country, you need to do that impact assessment. If you're entering into a data sharing agreement, you need to do a PIA because that increases the number of people who can see the data. If you're going to implement any type of large-scale data collection, so suddenly your volume increases, right? Or if you're going to outsource to a service provider, maybe from a data center, you're going to go to a private cloud, that's an impact assessment. If you go from private cloud to public cloud, that's another impact assessment that you need to conduct. Who should be involved? Of course, the information controller or the process owner, as well as the DPO should be there, IT, HR, legal, and security. So this is really a workshop. There's a lot of documents that need to be collated when you're putting together a privacy impact assessment. So there are also free tools that are out there that will allow you to track, okay, who has submitted what, and is the first step complete so we can proceed to the second step and so on. Okay, so we have some time. Let me talk now about our thinking again on compliance versus accountability. And like I said, compliance is just doing what's required. For example, I'm going to appoint a DPO, I've complied, right? But accountability is really doing what's necessary, right? Making sure that the DPO meets the risk level that you're facing. Making sure that the DPO is trained and educated and always up to date on the latest issues in privacy. In fact, I compare it a bit to dental care, right? Yeah, I brush my teeth because my dentist requires you to do it after every meal. But being accountable for your own dental hygiene means I do what's needed, right? To make sure I have no cavities and my breath is fresh all the time. You get the difference between compliance and accountability. Compliance is encrypting your data. Accountability is storing the encryption keys in a separate physical location, right? You don't encrypt your data and store the keys on the same database, right? That's not being accountable. I think many of you know what I'm talking about here. So when it comes to the obligations, it's the same thing. Like designating a DPO according to Section 21, Circular 1601, and so on means to comply, we want to see the designation papers. And then we want to see the name of the DPO on the website, and we want the details to be registered with the National Privacy Commission. Once you've done that, you've complied. But being accountable means that the DPO engages with top management, and the DPO undergoes continuing education. So it's doing what's necessary to make sure that the DPO is doing the right job. Same thing with privacy impact assessment, right? Do it one per program, process, and measure. But the other way to be accountable is really making sure that you update it as you go along. Security, will be talked about by Dr. Rolly Lansigan. Breach reporting will be talked about by Attorney Jacob. So My colleagues will be talking about those other obligations for the rest of the day. I guess to close, I just want to end with a quotation from Terry Falconer, who's the executive director of the Ghana Data Protection Agency. She says that you cannot have sustainable development unless you're people-centered, because the object of development is people, right? And you cannot be people-centered unless you have strong institutional privacy processes. Privacy to protect the data and the rights of the people that you're helping. She further goes on to say that you need some level of accountability and transparency to ensure that there is sustainable development. Privacy thus becomes a key part of the conversation, not just a regulation, to comply with, but a key to operating an efficient government, allowing government to collect data in an economic, accountable, and transparent manner. Right? You have to be transparent with what data are you collecting, what are you using it for, and how are you protecting that data. And she closes by saying that data protection can help address the causes of poverty and can help address the issues of trust. Because sustainable development means involving the people, and this involvement rests on respecting the principles of data protection. Right? So hopefully we do it because we want to help, because we want to reach our sustainable development goals. So just to summarize, after this session, you are now enabled to do the following. Meet the head of your agency and explain the need for a DPO. Yes? You can communicate the considerations in selecting a DPO. You can download the guidelines for documenting a PIA. You can identify the participants for the PIA workshop. And finally, you can schedule this workshop, ensuring that the head of agency, of course, and the DPO and process owners are there to participate. That's all I have. Thank you for listening. My email is Mapa@Privacy.Gov.PH.